But here was a case which had to do with human rights, which had to do with what the right to life, which is Article 21 of the Constitution of India, Article 14, which is the guarantee in terms of equality, Article 15, which guarantees that no one will be discriminated on the ground of, and the expression used is sex. And the submission which was made to the court was that obviously the expression, or at least according to our side, the expression sex, when used in a constitutional document, doesn't just mean gender, it would also include aspects like sexual orientation. I mean, that was such a simple argument. It was such a small step for the court to have taken or to have accepted, because the Delhi High Court had already done the work. But the court, I think, forgot its role. It took its role as an appellate court far too seriously. It forgot its role as a champion of human rights. And it did something which, you know, at a certain level can probably be described, I mean, apart from insensitive, it was savage, because the judgment is savage because it takes away rights. I mean, whatever else the business of the court may be, it's certainly not to constrict rights. It's certainly not to exclude elements of society who have been found to be included by a Delhi High Court judgment. So it's pretty easy for a Supreme Court to reject, because of the power, the discretionary power they exercise, to say that, well, no matter what, if this is what the Delhi High Court has done, we will let that be, and should Parliament decide that the law is otherwise, they can amend the law then, and we will test it then, instead of the other way around. So that, as I see it, is the first big flaw. The second issue is, in terms of identity, I think there was voluminous literature which Mr. Desai placed before the court and several other counsel placed before the court as to who is this segment, or what is this segment of society which was saying, please recognize us for who we are, we are not in anyone's way, but this particular statutory provision, without the declaration granted by the Delhi High Court, makes us feel incomplete, it stigmatizes us, it sort of makes us feel second-class citizens, not worthy of full moral, constitutional citizenship. I mean, it was a pretty easy argument, it was an easy argument to accept, but the point is not whether they accepted it or whether they rejected it. I think the point is that the Supreme Court doesn't even recognize that this was the issue before it. So that's a pretty sort of sad state of affairs. I want to say another thing, I mean, at least one thing to strike a slightly discordant note. Is there something good in this judgment? And frankly speaking, from, I think, an analytical point of view, I can't find any redeeming features, but there's something in it which you can probably take away, which is that at the end of the day, your Supreme Court, even though I believe it was plainly wrong, still, when you look at the judgment, I mean, this is, you've got to be particularly dispassionate to subscribe to this point of view which I'm going to articulate. When you look at the fact that they dismissed the they allowed the appeal and they dismissed the reviews without even granting an oral hearing in court, I think it says something about to the credit of the court that it doesn't succumb to media pressure. It succumbs oftentimes to media pressure, but at least on this one, it didn't. And sometimes I feel, as a lawyer, as a lay person, you may find that a bit this is a sort of an odd value. But as a lawyer, I think it's very important to have a Supreme Court out there which is tough enough, and even though it's sometimes, as it is, I believe here, wrong, to stand up and say that, well, maybe we got it wrong, we'll correct ourselves in the future. They haven't said that, but to stand firm in terms of the decision. So that's the only redeeming feature, the way I look at it. I'll probably spend a minute or two just on the way ahead. I think there's something which we should carry away. Most Supreme Court, we have one more attempt over here through the formal system. Very difficult to get through, but there is a curative petition which the Supreme Court is competent to take up, and my sense is that probably curative petitions will be filed. And if a curative petition is presented, then it comes up before senior judges, of whom at least one of the authors, Justice Mukhopadhyay, will be on that bench. So there's a sort of a little bit of a glimmer of hope over there. But unlike several other apex courts, where because of the number of cases they hear, it takes very, very long to reverse course, I see two sort of elements of hope. First, I see a dramatic change in the constitution of the Supreme Court in calendar year 2014. So you're going to have a new, lot of judges, 10 new judges in the next 12 months out of 25 or 27, which means the whole composition will change. So I think that's very positive. And the second thing is, because of the caseload in the Supreme Court, much more frequently than in other jurisdictions, an opportunity lends itself to correct itself. And so you often find, I mean, I'm getting a little legalistic, but you find that you frequently have two judge benches which get it wrong, and then the Supreme Court, in a matter of months sometimes, sets up a bench of larger strength, which then lays down the law which governs. So there's no appeal from that earlier two-judge bench, but the larger bench strength ensures that the wrong judgment of two judges is overruled, and so you effectively have another judgment to hold the field. So I think that is the other reason for hope. I think the fact that lots of cases of this sort can probably be brought up. Is this are there any other positives? I think there are. I think I don't think we should take the fact that the rest of the world is changing necessarily for granted. As I see it, there's a huge battle ahead. There are countercurrents across the globe, Russia, parts of Africa, etc. So I think the battle has to continue. But if there's one lesson I take away from this, it is that we have to increase the educational quotient as far as our superior court justices are concerned on issues such as the ones which were involved in this case. And the most striking, I think, if there's one thing I recall from the hearing in the Supreme Court, it was this. And this is probably what made the difference. When Justice Singhvi, and I suppose he was as a senior judge speaking more than Justice Mukhopadhyay, or at least I seem to remember more of what Justice Singhvi said than what Mukhopadhyay remarked. And Justice Singhvi said he knew of no gay person. He had never met anyone who was gay. He had never interacted with anyone who was gay. And I know if you're doing a forest case without having been to a forest, or if you're protecting, I think it's a serious issue. I think if you're trying to protect a pristine seashore or a river bank without having really experienced the joy of nature in those fields, or even doing there were judgments of the Supreme Court of India right up till the 1980s which are very regressive in terms of women's rights. And I think a lot of that comes from education. So I think the media role continues. Perhaps we've got to make a much stronger pitch at the judicial academies which are supposed to train judges. And if we get that adequate momentum in terms of a knowledge base or a sensitivity, perhaps we will have some reason to celebrate and not have a seminar like this one. Thank you.